person with anything to do before the justice, the question will now sitting in Boston Farm within the Commonwealth. Your Honor, give your attendance and you shall be heard. President of the Commonwealth of Massachusetts, this court is now open. Please be seated. Good morning.
Good morning. Good morning. Welcome to the Appeals Court. Let me introduce the panel. I'm Justice Shin. To my right is Justice Grant, and to my left is Justice Smyth. And we will be your panel for the 5 cases on the list today. As many of you know, the rules of oral argument are each side gets 15 minutes to argue. When the yellow light goes on, you should think about starting to wrap up. And when the red light goes on, it means your time has expired. And we do not allow rebuttal in the appeals court. The last thing I'll say is the panel has read your briefs carefully. We're familiar with the facts. And so I'd urge you to get to the heart of your argument. All right, with that, I'll call the first case, which is Commonwealth versus Piard, number 2023 P846. Counsel.
May it please the court, good morning, Your Honors. Edward O'Brien appearing for my client, Mr. Joseph Piard. On September 24th, 2019, at the time of Mr. Piard's post-arrest interrogation, he was Mirandized, and then about halfway through the interrogation, Detective Goff hits him with, and he tells him, I have incontrovertible scientific evidence that your sperm cells is located in the young lady's vagina. Asks Mr. Piard to explain it. Mr. Piard says, well, show me the proof. Detective Goff says, I'm not going to do that. At that point, Mr. Piard says, then, if you're not going to show me the proof, I cannot answer any more of your questions. Goff says, what's that? And again, Mr. Piard repeated, then I cannot answer any more of your questions. That is a clear, unambiguous, unequivocal invocation of Mr. Piard's right to remain silent. At that point,
did your client have a right to see the DNA test results?
a right to seek it.
To see. So in other words, what if it was a scenario where the police said another witness told us what happened, or we have surveillance video? Would a person being interviewed post-Miranda have a right to say, I demand to see that evidence before I continue the conversation?
Have a right to see it. I would say, Your Honor, honestly, eventually, obviously in discovery, at that particular time, I don't think there's any legal requirement for the officer to show it to him. But the issue here is not whether my client had a right at that point in time to receive the DNA evidence. The issue here is whether he clearly and unambiguously invoked his right to silence. And the other cases that were cited are very similar, with similar invocations about, there's this Santana case where the SJC ruled it was a clear invitation when the defendant said, I can't say any more. Commonwealth versus Conley, I don't have anything to say. Commonwealth versus Hearns, then I don't want to talk. I got nothing to say.
Counsel, let me just interrupt you for a moment, because this may be a little bit different, that it was qualified or conditional. It wasn't, I have nothing more to say. Initially he said that I can't answer any questions if I can't see the proof. And then he said, I can't answer any questions if I don't have any proof. So let's say the detective then, at that point, put down the DNA report.
At that point, we will never know what happened, Your Honor, if Detective Goff produced the report. It is a qualifier. If you're not going to show me the proof, then I cannot answer any more of your questions. Detective Goff wasn't going to show him the proof, never intended to show him the proof, and never did. So the qualifier stuck.
So the qualifier, the conditional, though, is that different than
It's a conditional, and the Commonwealth, Detective Goff never satisfied that condition. Instead, Detective Goff resorted to what the SJC and this court has repeatedly said is police misconduct. Rather than scrupulously honor my client's invocation of his right to remain silent, they pulled all the psychological manipulation and trickery in the book. Detective Goff says, "Oh, you're calling me a liar then." Mr. Piard says, "Well, no, I'm not." "Yes, you are. Do you think I would risk my career, my entire career for this? I would be in so much trouble," and so on and so on. It's a psychological, manipulative tool designed to get Mr. Piard to resume talking. And in the Smyth case, the SJC frowned on exactly the same kind of police misconduct to get the defendant to talk. In fact, I would submit the Smyth case is really analogous to this one. There's a clear invocation of the right to remain silent. There is police psychological, manipulative attempts to get the defendant to talk. And then thirdly, in that case, the court did find that there was a substantial risk of a miscarriage of justice. Like here, that error was not preserved. However, the defense here at trial was that the sexual encounter was consensual.
Do you have a case where the statement was conditional in the same way it was here?
I'm sorry, Your Honor?
Do you have a case, because Smyth does not involve a conditional statement, right? Do you have a case that does involve a conditional statement?
I don't, Your Honor, no, but I would say that that is not relevant because the Commonwealth never satisfied the condition.
Why is it's relevant, right? I mean, we're looking at what a reasonable officer would have understood the statement to mean. So, as Justice Smith asked,
if you cannot show me the proof,
all right,
then I have nothing to say.
Excuse me, counsel.
The
Can I
condition
finish? Could you please let me finish? As Justice Smith asked, at that point, had he put down the DNA report, there would not have been a violation, right? I mean, it was conditional.
It was conditional, exactly.
Okay.
Yes. And Goff never produced the report. He never showed him the proof.
All right, but a reasonable officer would have understood this statement to be conditional. Would you agree with that?
With a condition was which, if you show me the proof, then I will talk. A reasonable interpretation is then, therefore, the negative. The opposite is if I do not show the proof to this suspect, then he's not going to talk.
So you're saying that if the police officer had said, "We have the whole thing caught on surveillance video," and the defendant said, "You've got to show it to me, and then I'll talk," the police officer would have had to have shown on the surveillance video in order to continue
No, he has
the
a choice.
interrogation.
The officer has a choice. He can show the video, or he can terminate, as he's constitutionally required to do, the interrogation. It must be scrupulously honored. If he's not going to satisfy that condition, then he has to honor the invocation of the right to remain silent. Now, I disagree with the Commonwealth's characterization of the post-invocation statements as being merely cumulative of the evidence. There is a substantial risk of miscarriage of justice here because the KV, the young lady, the passenger, could not recall the events when she was in my client's lift. My client's statements here that after Detective Goff gets my client to talk, the kind of admissions that he made are damning and extremely damning at trial. She was kind of awake, not fully asleep. This is appendix from page 99 through 103. I'm not sure she knew what was going on. She was just laying there. Well, she wasn't fully passed out. She was mumbling, "Leave me alone, let me sleep." I pushed her knees aside, just laying there sort of asleep. Did she invite you to do that? No. Did she want you to do that? No. Probably didn't even know that it was doing. I just slipped. Do you understand you raped her? Yeah. In fact, the prosecutor in her closing statement categorized my client's post-invocation statements as a roadmap of a rape. These definitely hurt at trial, and they were unconstitutionally admitted, and just like in the Smyth case, it amounts to a substantial risk of miscarriage of justice, and the case should be reversed. The first, they call it an interview. It's definitively an interrogation. August 11th, where...
Did the police have probable cause for a crime as of August 11th?
On a probable cause? I would say no. I would concede there is probably not at that point in time. I think probable cause is established when they get the DNA result.
So how was it an interrogation if they didn't have probable cause that anybody had committed a crime?
The subjective belief of whether they considered him a suspect or whether the police consider they have probable cause does not enter into the calculus. It is not relevant. What is relevant is what an objective person would they believe they were free to leave. The groom factors, applying the groom factors, not one of them is determinative. You have a location, it's police dominated. Not only is the Boston police there, but the other elements of police. He's not at home, he's not in his familiar surroundings, he's double teamed. There's at least 2 officers in when they question him. Contrary to the motion judge's finding that the interrogation was friendly, this turned really hostile. In fact, I have quoted the extremely crude and sexually vulgar way in which I'm not going to repeat here in open court, in which Detective Goff questioned and sought to elicit statements from Mr. Piard. There are at least 2 clear errors in the findings of the motion judge. One, the motion judge was clearly erroneous in finding that the police told Mr. Piard he was free to leave. If you comb through the entire transcript of the examination, not once was Mr. Piard informed he was free to leave. The second clearly erroneous finding was that the police told Mr. Piard he was not a suspect. Never happened. It's not there. In fact, the tone, the manner, and the aggressiveness of the questioning would indicate to any reasonable, rational person that they were a target, that they were a suspect in a potential sexual assault. Therefore, he should have been Mirandized. And another indication, not to pick on the motion judge overly, but the motion judge makes a comment that, oh, the police offered him a glass of water, indicating that the conversation was friendly. That is a naive assumption. They were looking to get my client's DNA. And this, oh, you look thirsty. Can I get you a glass? That is a ruse, a subterfuge, a trick to get my client to drink from a glass of water so they can surreptitiously get his DNA without having to ask him for it.
But don't the cases on voluntariness talk about whether or not the person being interviewed has had anything to eat or drink?
I don't think I understand. I'm sorry, Your Honor.
Don't the cases about in the groom factors and whether statements are voluntariness, one of the things those cases sometimes consider is if the suspect is held for a period of time without anything to eat or drink.
Yes.
So what are police supposed to do? Can they offer someone a drink?
20 minutes into the interview? I mean, I think anybody looking this to say that they offered him a glass of water to be friendly is extremely naive. They offered it so they could get his DNA. This is maybe 20 minutes in, half an hour in. He makes no complaints. In fact, they ask him twice. The first time it's, oh, you thirsty? He says, no, thanks, I'm good. The second time, oh, no. He turns it down. That is not the circumstances here where the client is kept for hours and days without food or water, or he's a medical condition. No. We have a hostile environment, hostile interrogation, never told he's free to leave. He's clearly a suspect. Any reasonable person would believe he's not free to go. The same testimony, Nurse Petricone. All right, she's the sane nurse. She, did the the medical evaluation. From the beginning, the prosecutor elicited her education, her training.
Did she testify to an opinion that the victim was unconscious, or did she say that the victim said she was unconscious as a reason to explain why the nurse took samples from the areas that she did?
KV did not say she was unconscious. She said she did not remember what happened to her between the hours of 1:30 and 5:30. There is a form, I don't know if it's Form 4 or Form 5, on the SANE form that asks, was there a loss of consciousness? And Nurse Petricone in her, gave her medical opinion. She checked off yes. Why?
But that's under acts described by the patient.
Yeah.
Was
yeah.
there loss
I can't
of
remember.
consciousness?
And
Yes.
she gave the reason why she gave her medical opinion there was a loss of consciousness, because the patient does not remember anything between those hours, which was the time that she spent with my client. If I'm asleep, I am not going to remember events that happen when I'm asleep.
Okay, counsel, your time is up. We're going to have to leave it there.
I would just submit, Your Honor, that my client had no prior criminal record. He had roots in the community, coming here as a teenager from Haiti with his family. He had no prior record. He made bail. He satisfied all the bail conditions. There was an abuse of discretion of the single justice. She didn't consider my representations to that effect. She also did not consider the fact that if we have a reasonable likelihood of success on appeal, that she should have considered those factors as a
Counsel, we have your memorandum on this issue.
motive
so
not to run
thank
it.
you.
And I would ask the court to issue, if it would consider possibly, issue a ruling on the motion to stay prior to its decision.
Okay,
I
thank
thank you.
Right. I should have mentioned at the start of argument, this case is partially impounded, so please refrain from using the victim's name, as I know you're aware, Attorney Paris.
Good morning. May it please the court. Molly Paris on behalf of the Commonwealth, asking that this court affirm the defendant's conviction. Before I begin, I'd like to first note that the victim is watching on the live stream. I'd like to start with the motion to suppress the defendant's pre-arrest statements, which were properly denied for two reasons. First, at the time...
Could you speak up a little and maybe
Sorry.
pull the microphone closer
Sure.
to you?
At the time, on August 11th, based on the four factors in Groom, most recently articulated in Rosa Roman, the defendant was not in custody, and based on that, police had no obligation to provide him with his Miranda warnings. This was an interview that took place at the Family Justice Center. It didn't have the same coercive feel as a police station, and at the time, police had no indication of whether there was a crime. There was no allegation of a rape. All they knew at the time was that the victim had fallen asleep in the defendant's lift. There certainly wasn't any probable cause because, again, there was no allegation of a crime. The rape kit hadn't been returned yet.
Do you agree with the defendant's claims of clear error in the findings?
I disagree, Your Honor.
Could you point us to where the detective said that the defendant wasn't a suspect and that he was free to leave?
Sure. I'd like to first address the statement that Detective Goff told the defendant that he was free to leave. That's not in the transcript, but it is in Exhibit 12, which the court has before it. That was the audio recording of the August 11th interview.
But it's not in the transcript.
It's not in the transcript.
Do you have a time stamp?
I do. I know it was at the outset of the interview. I can find it. It's in my brief.
All right.
It was at the outset of the interview and then during the interview. And then as to the other challenge that counsel raises, that police didn't tell the defendant that he wasn't a suspect, the statement was that during the testimony at the motion hearing, Detective Goff said he didn't consider the defendant a suspect. And so while the officer's subjective considerations aren't really at play here, they do go towards...
But he never told him that. That's what the judge found, right? That he told him he wasn't a suspect.
I believe the motion judge found both that,
Okay, do you agree it would be erroneous to find that he told the defendant he wasn't a suspect?
yes, that's correct. I did
Okay.
not find that. But again, this is an objective inquiry, and any of the officer's subjective considerations only play into the fourth factor, which is whether the person at the time felt free to leave. And again, just speaking to the nature of the interview, the defendant wasn't restrained. He came to the Family Justice Center on his own accord. And the conversation was primarily conversational. The defendant was recounting his version of events. And in addition, the motion judge properly found that the defendant's statements at the time were fully voluntary. This was a 20-year-old college student. He was never in custody or threatened. There was no evidence of any mental or physical incapacitation, and the motion judge properly found that although there was a more extended back and forth as to whether DNA could be found on a victim of sexual assault, at no point was there any coercion or misstatements by the detective that would have rendered the defendant's statement at that time involuntary. The motion to suppress the defendant's post-arrest statements was also properly denied.
Before you continue, though, at some point, would you concede that at some point during that first interview, the defendant should have considered himself a suspect? I mean, the detective asked him very explicit questions. Did you touch her? Did you put your penis in any part of her body? At that point in that interview, would you agree the defendant may have thought he was a suspect in the presence of the police officers? We initially told him they needed to speak with him and was corrected by the detective, oh no, I asked you to come in.
I'd respectfully disagree, Your Honor, just based on the fact that under Rosa Roman, the groom factors, no one factor is dispositive. So they invited him to speak at the Family Justice Center. He agreed to come in. There were some more pointed questions during that discussion, but looking at the conversation as a whole, the defendant, again, was explicitly told by Detective Goff at the outset of the interview and during the interview that he was free to leave at any time. He wasn't restrained. He was a college-educated 20-year-old, so I don't believe he would have felt that he was in custody and he would have been free to leave under an objective analysis of this. Turning to the motion to suppress the defendant's post-arrest statements, at no point did the defendant clearly and unambiguously invoke his right to remain silent. This is a very fact-specific inquiry, and I think the defendant's statement, I can't answer any other questions if I don't have proof that my cells were inside of her, is distinguishable from the cases such as Hearns, Smyth, and Santos, where the defendant uses the word, I don't want to speak, as opposed to can't. And again, in this case, we have the conditional language that we don't see in these other cases. And Hearns, quote, well then, I don't want to talk, I haven't got nothing to say. And that was mere moments after the defendant, in that case, waived his Miranda rights.
Do you have a case where the statement was conditional like this?
I don't, Your Honor. I'm happy to look into that more and submit a 16L, but I did not find one in my preparation.
Well, you cited Girard. Girard cites a bit of a conditional statement, though it doesn't follow it to its end. That's a statement where a defendant wasn't under arrest, but he's with the police, and he said, I want an attorney if I'm under arrest. And the court found that condition wasn't met because he wasn't under arrest, so they found it was not unambiguous. You follow me?
Yeah, I follow. Maybe the circumstances in that case were different if defendant was invoking his right to counsel, as opposed to, hey, I'm not going to speak anymore unless I have this report, which I'm not necessarily even entitled to at this stage in the investigation. And again,
it wouldn't be an unreasonable interpretation of Girard to say the court's saying he didn't invoke because the condition that he qualified his invocation on wasn't present. Where in this case, I think you'd have to say the condition was present that he was invoking on. He wanted to see that report. He asked for it numerous times after saying he couldn't say anything. So you would agree that that condition, the proof, the report wasn't met, would you?
correct. Detective Goff didn't provide the forensic report, but as
Told him he didn't need proof.
I mean, I just think at this stage, he wasn't required to see the DNA, the forensic report. But again, it's looking at what a reasonable officer would have taken the defendant's statement to mean. And if it's not clearly and unambiguously invoking a right to remain silent, then I don't think whether the report was ultimately produced matters, because I don't think the condition matters to that effect. But again, looking at the statement in the context of the whole interview, it's unlike cases like in Santos, where after the defendant clearly and unambiguously invoked his right to remain silent, the defendant in those cases stopped speaking, and police had to kind of persuade the defendant to continue with the interview, whereas here the defendant continues speaking without hesitation after making this statement.
Well, that's one way to characterize it. Another way to characterize it is the detective kept him speaking and wouldn't kind of take no for an answer. But we can disagree on that, perhaps. But another question on this issue is, in the motion to suppress and partially argued in the defendant's brief, it seemed like there was an insinuation the detective didn't want him to see the report because maybe it wasn't as strong as the detective was making it out to be. And on appeal, the defendant argues that the evidence, or the detective overstated the evidence. I mean, the comparison is 1 in it's like 69 octillion. Or how do you describe the detective's description, or how do you characterize the detective's description of the weight of the evidence against DNA evidence against the defendant? Do you think it was overstated?
I'm not sure, just thinking I'd answer. I don't know if he overstated the evidence, but I'm not sure if that factors into whether the defendant clearly and unambiguously invoked his right to remain silent. I think that's a separate inquiry. I mean, at any point, the defendant could have invoked his right to counsel. He could have invoked his right to remain silent. He did neither here. And there was no substantial risk of a miscarriage of justice where the Commonwealth's evidence of the victim's incapacitation was overwhelming. There was testimony from the victim. There was testimony from her friend Eliza. There were even text messages that were admitted that the defendant had sent to his friend Alexandra. Look, I have this drunk girl in the back of my car.
That's a hard argument to make. I think that there's no substantial risk, given that he went on to make statements that she wasn't even able to speak at the time. Right? I mean, that's pretty powerful evidence.
I respectfully disagree, Your Honor. I mean, this wasn't a he said, she said case. There were certainly the statements that were made, and then additionally the DNA evidence that came forward later. And in addition, Detective Goff's questioning did not render the defendant's statements involuntary. The statement was, this is your one opportunity. Well, it's really your second opportunity. And I think this case is factually distinguishable from cases like Novo, where police repeatedly say, if you don't tell us now, you'll never have a chance to tell your story before the jury. And I think that's why now or never tactics are problematic, because they wrongly suggest that a defendant won't have a chance to tell his or her story to a jury. And they're more problematic in cases where a defendant invokes his right to counsel, or again is told that he won't get to tell his story to a jury, and that just wasn't the case here.
So going back to the invocation, I mean, I haven't found a case either where it was conditional in this way, so at least not in Massachusetts. So an officer can continue to speak to the suspect to try to talk them out of the condition. That's permissible. So let's say he said, I'm not going to talk unless I can speak to my mother first. And the officer says, why do you want to talk to your mother? You know, you're a grown man, and keeps going. And then eventually he makes statements. That would be okay too.
I think it depends on the circumstances.
Okay.
I mean, if the
so
suspect
how do we draw the line? Where do we draw the line?
I think it depends on what the condition is. If it's a condition that the suspect is entitled to at the time. For example, if the suspect's a juvenile, he's entitled to have.
He's not a juvenile, right? So he's not entitled to talk to his mother, but he wants to, and the detective tries to talk him out of that. Eventually does, and the defendant makes.
I mean, as of now, the case law makes clear that until a defendant has to clearly and unambiguously invoke his right to remain silent. And I think the case law that suggests that the defendant's use of the words, I don't want to speak, or something with a stronger intonation than using the word "I can't" coupled with the conditional language. I think those two tied together suggest that a reasonable officer would not have understood the defendant clearly and unambiguously offering. So I'm not sure if there's a clear line. I think it is a very fact-specific inquiry.
Well, I think there is a clear line. You're saying that eventually the defendant would just have to say, "I'm done talking."
That is the case law as of now.
Okay.
Turning to the prosecutor's closing arguments, the prosecutor's statement that the defendant's text messages to the victim after the rape showed his guilty conscience was a reasonable inference from the evidence where the text messages were admitted. The defendant texted her shortly after the rape saying, "Hey, how are you? How's your dog?" And the victim responds back, "What happened last night? I don't remember. I was too drunk." And at no point during that conversation does the defendant say what actually happened, that he raped her. And so in this situation where he's texting her to check in with what she remembers or recalls, I think it was a reasonable inference for the prosecutor to make this statement in closing. And in addition, the statement that the defendant didn't care about the victim and wanted to exploit her. Again, there were text messages before the jury where the defendant texted his friend where he took pictures of her and was essentially making fun of her. And this was also a case where the credibility of the victim and the defendant were key issues. And so the prosecutor was within the bounds of proper argument to both discredit the defendant's account of events as he testified at trial and also to respond to defense counsel's closing, where defense counsel attacked the credibility of the victim, saying that she didn't remember as much, or she remembered more than she was letting on to on the stand. Just briefly touching on the SANE nurse, she properly testified as to facts as reported by the victim. The victim at the time didn't remember what happened between 1:45 and 7 in the morning. The SANE nurse testified to that and then checked the box unconscious. All of this was before the jury, before the SANE nurse testified in Exhibit 18, which was already litigated previously. There was no objection to that testimony, and defense counsel never cross-examined the nurse on that issue. Seeing as my time is wrapping up, unless the court has any further questions, I'll rest on my brief. Thank you.
Thank you. Thank you both. The case is submitted. Next case is Commonwealth versus Ivy, number 2023 P1444.
Good morning, Your Honors. May it please the Court, Edward Gauthier for Amber Ivy. Ms. Ivy appeals the denial of her Rule 30 motion to withdraw her plea to first offense OUI based on the misconduct of the Office of Alcohol Testing. First, she is entitled to the presumption of egregious government misconduct because she did take her breath test during the relevant period. So the sole issue under Commonwealth v. Hallinan, which is the only reported case on this issue, is whether she can show that the misconduct influenced her decision to admit to sufficient facts, and I hopefully will explain to the Court why it did. I kind of parallel these cases, and I've done about 75 of these in the trial court now. I notice a lot of judges essentially paralleling the rationale of Dukin and Farrak in those misconduct cases, and I find that problematic for two reasons. One is, in those cases, the chemical composition of the substance is one factor, but there are other ways to challenge those cases: possession, trafficking, or distribution. In a case like this, where operation in public way can't be challenged, the only issue is impairment or 0.08% or higher. So clients, defendants like mine in this case, are essentially compelled to plead guilty regardless of the facts of the impairment, because there's effectively no way to challenge the elements of the offense. So in terms of whether the breath test in this case, which was nearly twice the legal limit, influenced my client's decision to tender a plea, it most certainly did, because the breath test evidence, as admissible, along with evidence, clear evidence of operation, and public way made
But
this
the
case
strength
completely
of
untriable.
the strength of the evidence of impairment is relevant, right?
According to Hallinan and the unreported decisions of this court, the strength of the evidence of impairment does play a role in deciding whether a trial court judge should allow a motion to withdraw a plea. And they've also, the other issue I have with these lines of inquiries is the focus on the penalty that a defendant receives. In the Duke and Farrak context, there are a lot of different penalties people receive because there's lots of different crimes they commit. Possession, trafficking, again, intent to distribute. They could receive jail time, prison time. So if somebody gets a really good deal, that's factored into the analysis about whether they would have taken the case to trial. But in my experience doing these cases and practicing in the trial court, a first defense OUI is a 24D in just about every case.
It's what, I'm sorry?
A 24D, one-year probation, driver alcohol education program, and 45-day loss of license is so standardized that I believe it's a mistake on a case-by-case basis to focus on the penalty, because in reality, essentially everybody gets the same penalty. And I understand that it is an unpublished decision from a few weeks ago in which one of the panel members, Justice Smyth, participated. That was a 24D standard first offense disposition. Unlike in this case, that case had no affidavit from trial counsel explaining any advice that may have been given. In this case, we have two affidavits. We have an affidavit of the defendant where she avers that had she known that the breath test would not be admissible, she would have taken this case to trial. And we have an affidavit from trial counsel to the effect that she also would have given different advice to her client.
What do we do with the fact that your client, by pleading, got the advantage of a dismissal of the operating to endanger, which made her not subject to the 60-day loss of license?
I do note that she was charged with operating to endanger as well as 2 civil infractions, and those were dismissed. However, I don't think there's any evidence in the record to suggest what the practices and protocols in the court were in terms of how that would have been handled at the plea stage. And also, there's no guarantee under the facts of these cases she would have been convicted. But we do.
The judge referenced that in his decision. That was a
Yes,
factor.
the judge did was faithful to the Hallinan decision. He did his analysis. He basically cited to the facts in the record and the fact that the defendant did receive a disposition that did call for the dismissal of several charges. I don't take any exception to the legal citations by the judge. I mean, everybody who has done these cases knows there's one case. There's one published case. It's Hallinan. But my take on Hallinan is the Supreme Judicial Court did not take Hallinan because of the facts of that case. It took Hallinan because it was the one case that initially raised the breath test issue. So I think it's a mistake to have Hallinan as the line in the sand, where any facts that are worse than Hallinan means the motion has to be denied, and any facts equal to or less than Hallinan has to be allowed. I just think it happened to be those facts in that case. Any other case could have been the breath test case. And I do believe that a panel of this court 3 weeks ago does note that they did reverse the denial in Schnupp of the trial court's denial of the Rule 30 motion, but it did note that the facts in Schnupp are worse than the facts in Hallinan. And we would concede that the facts in this case are not the same as the facts in Hallinan, and could arguably worse than the facts in Hallinan. But we believe that that is not the line in the sand. That it's essentially, what it really comes down to in my experience is just a judgment call. It's really just a judgment call, and every case that I've done, the judge simply looks at the facts of the case and makes a judgment call whether they believe the defendant should be allowed to withdraw their plea based on the facts of the case. So these cases are entirely driven by the underlying facts. And so the court, I'm not going to read the police report to the court. It's in the record appendix. It is the facts of the case. There is no plea hearing transcript.
The facts don't really help you either. I mean, she's driving the car with a piece of the car dangling and sparks flying up when the trooper sees her, the officer sees her, correct?
Yes,
There's sparks flying up.
that is correct.
You've tried a lot of cases, maybe. There's a lot of different scenarios, the OUI facts, but there's not a lot that we see or that I've seen prior job postings where there's sparks flying. And then she can't even stand up for very long during the field sobriety test, and she's over twice the legal limit. I'm sure I'll hear from your brother. He'll likely want to emphasize these facts. So these cases are very factually specific, but I would say that your facts for your client, again, I don't want to say they speak for themselves, but they are distinguishable from other cases this court has heard.
This court and the SJC has heard very few of these cases, I would say, compared to the number of cases that have been heard in the trial court. And drawing on my experience doing these, I can tell this court that I've won cases with facts worse than this, but I've lost cases with facts not nearly as bad as this. So in my experience, there's no standard where I can tell the client, this is a winner, this is a loser. I frankly just don't know. If the court has no further questions, we would ask that you reverse the trial judge's denial of our Rule 30 motion.
Okay.
Thank you very much.
Thank you, counsel.
May it please the court. Good morning, Your Honors. Henry Souza, Assistant District Attorney for the Bristol District on behalf of the Commonwealth. Your Honor, I'm asking that you affirm the lower court's denial in this case. As we seem to have no contest, this is squarely a Hallinan-controlled decision, and we were fortunate enough to have a written decision by the district court justice in that he carefully applied and cited the Hallinan decision. I don't believe that there is an error of law, which would turn this standard of review almost solely to abuse of discretion, and whether or not a reasonable person would have pled guilty or rejected the plea under these circumstances. And I think that this case is truly distinguishable from Hallinan for three basic reasons. The first of which, as discussed, is the substantial evidence of intoxication that would have been admissible at trial under the intoxication theory had this case proceeded. There is especially egregious operation in this case. As Your Honor stated, there was at 2:15 in the morning traveling on Route 195 Interstate Highway, a vehicle observed by the state trooper to be weaving from the right lane into the middle lane, almost striking a median barrier and dragging a portion of the vehicle, causing sparks, but also a loud grinding noise prior to the traffic stop. Those facts, coupled with the observations that seem to check all of the boxes for the classic indicia of intoxication, from the odor of alcohol to the bloodshot glassy eyes, slurred speech, the admission to consuming alcohol that night, as well as going outside of the standardized field sobriety test, just a simple recitation of the alphabet seemed too great of a challenge due to, with the physical condition of the defendant roadside. This differs greatly from the facts in Hallinan, where there was no observation of any erratic driving. And I know the SJC has pretty plainly stated in and forgive the pronunciation, the Jewett decision, that the manner of driving is a substantial consideration for the effect of intoxication on a operator. Similarly, Your Honor, I would suggest that the affidavit submitted in this case by plea counsel is substantially different from the one presented in Hallinan. The Hallinan affidavit included a line from from plea counsel that in his experience he would have recommended the matter go to trial because in his trial history, he believed that juries frequently acquit drivers in a similar situation to his client was in that case. Here, the affidavit I submit is slightly better than having no affidavit. It does not once address the issue that is before the court, which is whether or not the attorney would have altered their recommendation to the client based on the exclusion of the breath test. The affidavit, I believe on page 15 of the record, states that I would have advised my client to permit me to file requests for further discovery to learn about the Draeger alcohol test 9510 devices and how that would have pertained to my client's case. Does not make any assessment of the strength of the Commonwealth's case or any diminishment thereof. And interestingly, curiously, This affidavit was authored after the conclusion of the Anais litigation and after the publishing of the Hallinan decision. So this information of the potential effect would have been available to counsel. Yet still, it does not discuss at all what the advice to counsel would have been, whether to try the case or to enter into that plea. And I would suggest to the court that the evidence of intoxication is overwhelming based on...
It does also say that if the breathalyzer had been excluded, you would consider trying the case.
Yes, and she did. And I would suggest that she considered trying the case at this point in time regardless. It was scheduled for trial, as was referenced in the docket as submitted part of the record. It was scheduled for a trial date and then I believe advanced for or continued for a plea. So I would suggest to the court that the affidavit truly does not go as far as the Hallinan affidavit, wherein the attorney would suggest a different course of action.
But how do you're a defense attorney and you have a case and the breathalyzer is more than double the limit, and the Commonwealth can proceed on a .08, correct? I mean, how does that not influence your discussions with your client?
Well, Your Honor, in my experience in the district court, I guess the analysis would have to be, would they try it knowing that that would be excluded for the purposes of this motion? And in my experience with the district court and in analyzing what the potential evidence was, in addition to all the indicia that I stated before, and as Your Honors had referenced, nearly falling over twice, having to catch herself on a vehicle, as well as her demeanor being aggressive and argumentative and threatening towards the officer, part of the defense consideration must be how would that evidence appear to a jury? How would that sway their opinion of the defendant, and would that be congruent with the common understanding of intoxication, in addition to the manner of operation, which in this case is, again, egregious. But I would also suggest to the court, as hit on by my brother, the charge concessions in this case do represent a substantial consideration. This is greater than what was offered in Hallinan, and I would suggest to the court that the dismissal of the negligent operation particularly did relieve the defendant of substantial potential punishment should the matter have gone to trial, has a minimum sentence, not a minimum mandatory, but a minimum incarcerable sentence between 2 weeks and 2 years. It carries an additional loss of license of 60 days minimum, as well as any fines or fees as called for by the statute. I would suggest that when paired with that dismissal represents a substantial consideration. Also, when looking at the continuance without a finding for 1 year with a 24D disposition, the defendant qualifies under that first alternative for a lessened loss of license of 45 days, that being much less than if she were to be found guilty of the offense, which I believe to be 1 year loss of license. Similarly, any other potential penalties with the Registry of Motor Vehicles are alleviated by the dismissal of the charge, as well as the not responsible findings entering on the civil citations. There are a number of considerations for why someone would not want additional points or fees or fines, or in fact responsible findings that could contribute to the finding of, for example, being a habitual traffic offender, or other things that could impact or delay the reobtaining a driver's license from the registry. And I would further add that with the continuance without a finding, should the defendant successfully complete probation, as I believe Ms. Ivy did, it would result in dismissal. She would not have to be a individual convicted of a misdemeanor offense, which includes for any statement or inquiry by any governmental body or employer about has she been convicted of a crime or not. And I think that also is a substantial consideration for the defense. In this case, but also in general. I know my brother mentioned that this seems to be a standard disposition, and frequently it is offered prior to trial. After trial, the defendant would not be entitled to a continuance without a finding, would not be entitled to a dismissal. If she were convicted just solely on the negligent operation based on the anticipated testimony by the officer of the observed driving, she would be facing a greater loss of license than what she in fact obtained by the plea, as well as I would suggest the guilty conviction, which by itself has a number of other considerations. And if your honors don't have any further questions, I'm happy to rest on my brief and ask that you affirm the lower court's ruling. Thank you.
Thank you, counsel. Thank you both. The case is submitted. The next case is in the matter of the Robert A. Kangas Trust, number 2023 P1261. Hold on just 1 second, counsel. It's very warm in here. Sure. Yeah. Okay, whenever you're ready, counsel.
Good morning. May it please the court, Lindsay Chen on behalf of Rosemary A. Portrait. We are asking you to reconsider and grant a motion for stay pending a review of this appeal and to reverse the trial court's decree and order numbered 1, 2, and 3. First, we ask the court to reconsider and grant a motion for stay pending this appeal because our client meets the 4-part test for a stay. Property Acquisition Group LLC v. Ivester outlined a 4-part test for an appellant seeking a stay. The appellant must demonstrate 1, the likelihood of appellant's success on the merits, 2, the likelihood of irreparable harm to the appellant if the court denies the stay, 3, absence of substantial harm to other parties if the stay issues, and 4, the absence of harm to public interest from granting the stay. Justice Sachs denied a reviewed motion for a stay pending appeal because he noted, in quote, the appellant does not have a substantial likelihood of success on the merits for her argument that the trustee lacks authority to sell the property, and also because granting a stay here would at most delay but not prevent any irreparable harm to the appellant. We respectfully disagree with both reasons and find that one does not only does our situation meet all 4 tests, but that delaying irreparable harm to the appellant is not a reason to strike a motion to stay. To address the first factor, the likelihood of appellant's success on the merits, we remind the court that our primary argument is that it was unnecessary for the court to remove Rosemary as trustee and appoint a new trustee, adding the power to sell the trust property. Upon reviewing the trust and title, we have multiple disagreements with the lower court's findings, including the trust did terminate, the trust language did not dictate selling as a power or directive based on the trust's termination, and that the winding up period requires a complete distribution of trust assets according to the terms of the trust. Since the trust did not specifically say, sell the property upon the death of Mary, co-owning this property should have been considered an option, but it was summarily rejected by the probate court judge in her ruling.
Well, could a trustee have simply given Kurt cash for half the fair market value of the property?
Based on the terms of the trust, they use the word distribute, not sell and distribute. So our argument has always stood to be that distribute means convey, meaning it would be deeded as tenants in common. So distribute to beneficiaries would be convey the property to Rosemary and her brother Kurt, the 2 beneficiaries, as tenants in common. So we believe that if there was a monetary value to come into play, it would have to come through a petition to partition, which is what we offered, because that would allow
Counsel,
her to.
I wasn't aware that the motion for stay was even before us. Did you file an appeal from Justice Sachs's order?
I believe we did. We did.
I'm not seeing it on the docket.
Okay, I'll have to double check that then, but I was under the impression from others that it was filed. But that being said, just moving forward, do you want me to move on from the motion to stay then?
What do you do about the fact that Article 10A of the trust gives the trustee the authority to sell, exchange, buy, mortgage, lease, or pledge any real or personal property for such consideration and upon such terms as the trustee considers advisable? Are you saying that it would not be in the trustee's power to sell the property?
So those are trustees' powers when the trust is active, but one of our arguments that we still stand by is that the trust terminated. The trust terminated as dictated in paragraph 2.4 of Article 2. It quotes, "Upon the death of Mary V. Kangas, the trust hereunder shall terminate, and then the then remaining trust property, together with accumulated income, if any, shall be distributed to Rosemary A. Portrait and Kurt Kangas." The two important points to note here is that the trust did terminate, and the property shall be distributed to Rosemary and Kurt. So the period that we're currently in right now is something known as the winding up period. That means that the trust can dictate different terms for this period of time, which here, again, are dictated by 2.4. So although there was talk about selling as a power in paragraph 2.2 of Article 2 and paragraph A of Article 10, those were actually superseded by the clear intent from what the trustee wanted to happen once the trust terminated, which was to distribute the property to his two children.
Does the trust say anything about, I'm setting up this trust to take care of my two children and then show that they can live in this house forever?
I don't know the answer off the top of my head, but if the court wishes, I'm happy to follow up with a letter.
The point of the trust, though, was to take care of Mary, the mother.
So it was a two-part intent. So the first was to take care of Mary, and the second was to leave some asset behind for the children. The donor actually asked Rosemary to come move in with the family in 2010 to help care for him and his wife, because he knew that, his health was declining, and he wanted to make sure that she could be a caregiving child that would actually provide for both him and his wife. But as kind of, I guess, a give back, he wanted also to make sure that she was provided for, along with the son, which, although the son has been estranged from the family since 2010, I think he felt a fatherly duty to at least include, the son in the deed that he hoped would eventually transpire after Mary passed away. So I guess I'll move over to that area, which we asked the court that they should reverse order number 2, ordering the successor trustee to terminate the trust, ready and market the trust property for sale, and then disperse the assets as directed by trust, because this grants a trustee a power not originally authorized by the trust. As I mentioned, the trustee's powers were broad in the beginning while the trust was active, but they funneled down and narrowed down as the trust terminated. The restatement second of trust, section 164, provides that trustee must perform their duties in accordance with the terms of the trust, which in turn supports the principle that courts should not impose duties or grant powers beyond those outlined in the trust instrument.
I have a question for you. When did Rosemary individually and Kurt become qualified beneficiaries of the trust within the meaning of Kalekia and Schwam?
Yep, so based on Schwam, Rosemary and Kurt were contingent beneficiaries until their mother's death, which triggered them to be qualified.
And what was that date?
So that date was...
September 2nd, 2022?
Correct, September 2nd, 2022.
So in the judge's order, when he ordered Rosemary to give an accounting of the assets of the trust from September 1st, 2012, going forward, where did that September 1st, 2012 date come from?
So that was a request by Kurt, not really stating other than the trust was around in 2012, so we want a full accounting from then until now. But again, Kurt couldn't really request this accounting from 2012 because he wasn't a qualified beneficiary. He wasn't entitled this.
So would you agree that if Kurt had requested an accounting beginning on September 2nd, 2022, the day Mary died, that would have been okay?
Yeah, it was proper, and actually, we gave an accounting from date of death to Kurt and through his counsel, so we have provided that already, just as, to comply with that, and we've offered to give that, but the truth of the matter is that the trust only holds the property. There is no bank accounts, there is no other assets that really deal with the accounting. Rent was paid directly to Mary while she was living, and she paid for the expenses of the property out of her own funds as well.
But as your brother counsel say, how do we know then if there's no accounting?
So there was confusion on the part of Mary and Rosemary that the house, again, was even in trust. They weren't aware of it, and that's why they executed a life estate deed in 2018, because they believed that the house was owned by Mary solely. So they executed a life estate deed in order to get her into mass health and start the 5-year look back. But going back to reversing order number 2, I just want to make the point that in our case, the trust purpose was clear. Preserve the house first for the donor's wife, then for his children.
Where in the trust document does it say that the goal was to preserve the house for the children?
Again, I think that I don't want to take up too much time from my argument section, but I would be happy to submit a letter with a little bit more detail.
Article 2.1, this trust is for the benefit of my spouse, Mary V. Kangas, of said Medford, Massachusetts, for the term of her life.
Yep, and so even though I'm saying that Rosemary, and we still stand by the fact that Rosemary was unaware that she was trustee, she did as her father directed and as her father intended, because she took care of her mother, she moved into the house, she always made sure that the house was paid for, bills were paid, her mother was taken care of, and she kept her mother there for as long as she possibly could before she had to enter a nursing home. So even despite her being unaware of the trust, until actually opposing counsel brought it in a letter to her, she
signed something at the time the trust was created back in 2012 saying, I'll take on the responsibility as trustee.
So her father was very ill at the time, and she signed a document that was separate from the actual trustee certificate. I think that's what you're referring to, the trustee certificate that she signed. That was on a separate piece of paper, was the signature page, and her father was sick at the time and just asked her to sign it. She was quite flustered. I know it's a horrible concept that, you're signing something without knowing, but the truth of the matter is that she was, she's over 65. Her parents are not in great health, and her father asked her to do something, and out of compliance and just being a good child, she signed the document. But that also was improper, just because the trustee certificate should be signed by the current trustee, and she wasn't the current trustee until her father passed, but her father was the one who had her sign it. So again, not quite fully valid, but the court ruled that it was. So just touching upon the accounting, we ask that the court reverse that order as well, and that's order number 3. Again, we just want to say that MUTC and common law, a trustee has a duty to account.
What's the standard of review on this issue?
The standard of review, I believe, is clearly,
Isn't it abuse of discretion?
Abuse of discretion, yep.
Okay.
It's abuse of discretion, and we thought there was an abuse of discretion because not one of the qualified beneficiaries requested an accounting during that active time, which again would have only been Mary until 2022 when she passed away. Then it would have been Kurt and Rosemary, and both of them from then on were entitled to request.
He's now a qualified beneficiary.
Correct, and
so
we gave them.
He's entitled to an accounting, right?
Yep, and we provided one.
So why is it an abuse of discretion to order the accounting going back?
All the way to 2012.
Right. Why is that an abuse of discretion?
Because it grants, it allows for an accounting that wasn't ever asked for by someone who was qualified. There's
nothing in the trust that forbids that accounting, right?
It just says, the term that they used in there was Article 6, it had language consistent with the statutory and common law language, saying that could only be made to income beneficiaries, where income beneficiaries meant qualified beneficiaries. So again, the income...
Now he's entitled to an accounting, and there's nothing in the trust document that prohibits what the judge did. So you need to show it was an abuse of discretion, and I'm not understanding what your argument is on that.
I apologize. I would say that the abuse of discretion just comes from the fact that we didn't feel that anybody was entitled to an accounting prior to 2022 other than Mary if she requested one, but she had not. And then post-2022.
Based on what? Based on the trust document or some other reason?
Based on the trust document, and there's actually even question on whether anybody is entitled to accounting post-2022, because again, we believe that the trust terminated in 2022 upon the death of Mary. So there wasn't any specific terms on, during the winding up period, who was entitled to this accounting. And then just going back, so our last request is that the court reverse order number 1, removal of Rosemary as trustee of the Robert A. Kangas Trust, and the appointment of John H. Hudd or Attorney William H. Mayer as successor trustee because she was unaware of the trust, but upon learning about it, willing to abide by it.
It looks to me as though she wasn't immediately willing to abide by it. This took quite a bit of hearings in probate court, that including one that she didn't show up for.
So it would appear that her brother already had intent to sue her, and we actually offered and sent a letter through counsel offering to deed the house as the term dictated to both her and her brother as tenants in common, and they pushed forward. They told us not to do anything and pushed forward with litigation. But she has always been willing, once she found out that she was trustee, to do whatever the trust dictated, which again was to deed the property as tenants in common to her and her brother. And that was the only words that talked about what would happen after the trust terminates. And again, that's 2.4.
Under Article 2, 2.4, the phrase distribution, you'd like us to convey that as, or to interpret that as conveyed to a quit claim.
Correct. And we have
Basis for that. They didn't say that, and you ask us to look at the plain language. The plain language says distribute.
Yep. So distribute tends to mean convey unless it's coupled with with other words. That's seen by case law, seen in Taylor v. B&B Realty and Loring v. Marsh. They used words such as sell or proceeds along with the word distribute when they actually meant to sell and then distribute the proceeds as such. And it would have been simple enough if that was Robert's intent, that they get the divided proceeds to just say in 2.4, sell and distribute the proceeds to my son and daughter. But unfortunately it wasn't. It was just distribute.
Your time is up. Just let me check if there are any questions. All right. Just to be clear, counsel, the purpose of a post-argument letter is not to raise additional arguments. Yep. So if the court wants additional briefing, we will ask for it. Okay?
Okay. Thank you.
Counsel.
Good morning. May it please the court, Timothy Robertson on behalf of petitioner appellee Kurt Kangas. So the couple issues before the court are the appellant claiming that the trust terminated and the powers of sale contained within the trust are at that point null and void. A trust doesn't just surreptitiously terminate and the parties walk away. Under the trust code, a trustee has a duty to expeditiously distribute the trust property and also provide an account. And at no point did the trustee, Rosemary, provide an account or distribute the trust property. In the lower court, she actually denied she was even the trustee and denied that the real estate was the record title holder to the, denied the trust was the record title holder to the real estate. So it was impossible for the trust to terminate because she denied she was even the trustee or that the trust owned anything. So it's sort of this circular logic that the trust terminated, but she also wasn't the trustee. So we have these shifting contradictory arguments that just result in this sort of delay. Now, if she did distribute the trust property to the beneficiaries, it would have required a different legal analysis. Maybe we move forward with a partition action, but we're not going to go to probate court, file a petition on a general trust petition, and then have them drag it out to a further partition action when she denied she was even the trustee to begin with. The whole reason we had to file the general trust petition is because no one was taking action with respect to the trust, and she denied she even had the authority to do so. So it was impossible for the trust to terminate. And under Rothwell, the case law shows that a trust doesn't terminate until a final account is provided and conveyance or some distribution is made. Here, none of that happened because, again, she denied she even had authority to do so. And so we had to go into court and request a successor trustee to actually carry out the terms of the trust. As far as the accounting, I don't think there's a question that Kurt Kangas is a qualified beneficiary of the trust. And again,
When did he become qualified?
on his mother's passing. And so
Well, that's September 2nd, 2022.
that's correct. And so he's entitled, now what the appellant is arguing is that it would be unduly burdensome for her to create these accountings going back, but she was under a duty this whole time to create annual accountings. If a qualified beneficiary asks for prior accountings, it shouldn't be an issue for a trustee to just say, here are my records. And they have a duty to keep records under the common law and the trust code. And so how would a beneficiary know whether a trustee was stealing money or otherwise depleting the trust assets? Even if he didn't have a claim, the estate of the lifetime beneficiary could potentially have a claim against the trustee, but no one would know if there's no record keeping.
So where does the date, September 1st, 2022, in the judge's order September 1st, 2012, come from in the judge's order? It doesn't coincide with anyone's death.
No, it coincides with the inception of the trust. So the trustee has a duty to keep records from the inception of the trust to present.
So it's the first day of the month after Robert's death? Is that why it's picked? So he died August 8th, 2012.
Right.
And so the date that's in the order is September 1st, 2012.
Yeah.
Is it picked because it's the beginning of the month following Robert's death?
I don't know the answer to that question. But in any event, she does have a duty to create these annual accounts. The terms of the trust provide that. The trust code provides that, and it's well settled under common law that a trustee will keep annual records pertaining to the trust activities. And so if she kept those records, then it wouldn't be unduly burdensome. So it seems to be a general plea that she has to do some work that she was charged with doing, but decides that this court should not force her to do something that she was charged with doing to begin with.
So you agree that there has to be language in the trust instrument giving the trustee power to sell the property, right?
Well, there's two different powers of sale in the
Right,
trust.
but you agree there has to be such language, right?
No, the trust code provides that as well. The trust code provides for a general power. Any competent unmarried individual has all the powers. The trustee has all the powers of a competent unmarried individual over trust property. That's
So it doesn't matter what the trust instrument says?
The trust instrument can limit the powers of the trust code, but the trust code provides these general powers as well as specific powers, which includes the power to sell real estate.
So if there's no limitation in the trust instrument, you're saying that MUTC applies?
There's no limitation in the trust instrument. Instead, there's two broad
I'm
powers.
asking you a legal question. So the MUTC gives the trustee the power to sell unless there's a limitation in the trust document? That's what your position is?
Yes.
Okay.
And so there is no limitation in the trust instrument. The trust instrument actually says that it will supplement the trust code, and in the instrument itself, it provides two unlimited powers of sale. The appellant is asking the court to infer some limitations that just don't
Well,
exist.
2.2 does seem to apply only during Mary's lifetime, because it ends with the clause necessary or advisable for the benefit of the beneficiary, and the beneficiary is defined as Mary.
Is the beneficiary defined as
Yeah.
Mary?
This trust is for the benefit of my spouse, Mary, here after the, quote, beneficiary.
The trust is for the beneficiary of Mary during her lifetime, and then for the contingent beneficiaries, Kurt and Rosemary. They're all beneficiaries, whether it's singular or plural, he or she. I don't think
Well,
those.
I mean, it defines beneficiary as Mary.
With a capital B.
Yep, with the
In-
capital B,
with
that's
a
true.
Parenthetical.
I mean, this isn't the most clearly written
She's the
document
initial
I've seen. but-
beneficiary. There's no dispute about that. She's the initial beneficiary. Then we have contingent beneficiaries. They're all beneficiaries.
Yeah, I mean, okay.
So, I mean, she's under, as I was saying with respect to these accounts as well, she's under a duty to create annual accounts, and she's claiming it's unduly burdensome.
And there's no evidence the donor ever waived that.
There's no evidence the donor waived that. The beneficiaries certainly haven't. And so we're requesting cost, damages, and attorney's fees because our position is that this appeal is frivolous. She's already agreed to vacate the property, and the trustee is moving forward with the sale at this point. And so I don't know what the effect of any of this would actually be. All that would really happen anyway is that we'd have to file a partition action and just continue to delay this. And the ultimate disposition is not in question. The property is going to be sold and distributed to the two beneficiaries. It certainly wasn't the donor's intent for them to engage in protracted litigation and be fighting with each other, nor was it the donor's intent for one beneficiary to benefit herself to the detriment of the other. You know, the trustee's moving forward with this, and I'd rest on my brief and request cost, damages, as well as attorney's fees.
Okay, thank you, counsel. Thank you both. The case is submitted. We'll take our mid-morning break right now, and we'll be back in about 15 minutes.
All rise.
Good morning, Your Honor.
Good morning. Still morning, still morning. We'll continue our session with the fourth case, which is in the matter of a minor, case number 2023 P1100. I'll remind both attorneys that this case is impounded, so please avoid using parties' names.
Thank you, Your Honor. May it please the Court, my name is Andrew Cantor, and I represent the appellant, who for privacy reasons I may refer to as LT. The appellant appeals the July 14, 2023 order committing him to a drug rehab facility pursuant to Section 35 of Chapter 123 of the General Laws. LT was clearly a troubled young man. He was the subject of a child welfare proceeding. He was placed in DCF custody, a placement from which he ran. He was missing for approximately 2 months until he was apprehended by the police. There were allegations of serious criminal activity, drug use, drinking. But the question before the lower court was not whether LT could benefit from services. The question was not whether he just needed help. The question before the lower court was a very direct and specific one. LT was ordered to a drug rehab facility against his will. That involves a deprivation of his liberty. And the question before the lower court was only whether or not he suffered from a substance use disorder, which would have presented a physical risk of imminent harm had he not been committed. As we argue in the brief, there was not clear and convincing proof of this fact, and he therefore appeals the entry of the commitment order as wrong. To begin with, Your Honors, the first question that the lower court would have considered is whether LT suffered from a substance use disorder. The evidence on that was based solely on hearsay, and in Section 35 proceedings, hearsay is admissible, but only to the extent that it is reliable. As I argue in the brief, the only evidence regarding the appellant's use of drugs is the clinician's secondhand account that he was using marijuana on a regular basis. That was the totality.
Well, before you speak in depth about that, so the probation officer did write in the petition, in the affidavit under oath, that he essentially uses daily.
That's correct, Your Honor. And
you cite a case, I think you cited it as a SJC case, but I think it's an appellate, district court appellate division case, which states that, in that case actually stated just an expert testimony alone in that certain case wasn't sufficient. But I ask you that because in any case or in any evidence, in any commitment hearing, are you saying that a judge cannot rely on a sworn affidavit of a probation officer?
Yes, Your Honor. I cite two cases for that proposition, one being the Appellate Division Southern District case, which seems to suggest exactly that the pleading, which is just that, it's an allegation, is not a substitute for testimony. Clearly, the clinician could have also testified what was in the petition, but she didn't do that. And so I would suggest that the petition itself...
But she said she relied on the petition, correct?
That's correct. That's correct. And I believe that was an error. But in any event, Judge, it really is of no moment, because even if the court considered the petition correctly, that doesn't really resolve the problems with the hearsay. The hearsay is still unreliable. All the evidence was that he uses marijuana on a regular basis.
Could I just ask you about the affidavit? The relationship, the affiant says the relationship to the respondent is assigned probation officer this morning when he was brought in by police. And then later, the probation officer says he uses marijuana daily. Isn't that coming from the mother?
Your Honor, it's not clear exactly who it's coming from.
It's not that the probation officer has any prior dealings with this minor, right? Because it says assigned this morning. Is there some pre-existing relationship?
I think probation draws that inference of that it's coming from the mother, but the clinician spoke to a number of people. And again, that's sort of the problem with the reliability of the hearsay, is that it doesn't specifically say, I spoke to so-and-so, or so-and-so told me this.
But is there any evidence in the record that this probation officer had directly observed the minor at any point in time?
I don't believe so, Judge. I think it's all secondhand. I think it's what the clinician was told by the mother, the clinician did some investigation, spoke to a number of people. And so we don't know who provided the evidence of the drug use. And that's exactly the sort of the problem, that if you look at the factors, that what a court considers as to whether something is reliable, this hearsay lacks all indicia of reliability. Who told the clinician that he was using? What specifically did that person say? What is the relationship of that person to LT? Is it a friend, a relative, an enemy, someone with an interest? And so the fact that none of these corroborating details makes the hearsay unreliable.
It seems reasonable to infer that the sources were the mother and the aunt.
I'm sorry, Judge?
It seems reasonable to infer that the sources were the mother and the aunt. But
Yes,
still, the question still remains whether there is enough there to say he had a disorder.
Judge, neither the mother nor the aunt testified. The only person that testified was the clinician. And again, the clinician is getting this secondhand from various sources.
What do we do with the fact that the mother was present at the hearing with an interpreter? So she heard all of this and either counsel could have asked to question her about the underlying hearsay.
Mother was not sworn as a witness, and so she wasn't a witness.
But she was available.
She was available, but it is not my client's burden to disprove the case. The burden of proof is on the petitioner to prove the elements of the petition. And in any event, Mother was there. Mother didn't provide any, even if it was testimony, even if it was one, didn't offer anything about her son's use. Again, all we get is from what she supposedly, we're led to believe through inference, told the clinician who then reported it. But again, the testimony, which is what I'd urge this court to focus on, was the clinician's testimony that, quote, multiple sources say that the child was using drugs. A related but independent problem is that even if the hearsay was reliable, it fails because the court didn't indicate why it found the hearsay to be reliable. This is a very important point. Case law suggests that the obligation on the lower court to specify why the hearsay is reliable is critical. It's a matter of due process. If the court's going to rely on secondhand sources, the least we could ask is that the court characterize why it found the hearsay to be reliable.
Would the remedy for that be a remand or a reversal?
The remedy for that would be to vacate the order.
Wouldn't it be a remand for the judge to make the findings that he should have made?
I suppose that there could be then another proceeding to determine whether or not he, met the petition. But I would note that he's no longer committed. But in any event, on that point, probation argues that the appellant failed to object. And as I note in the brief, Judge, that there's nothing in the law that would require the appellant here to object, that would be impermissibly burden shifting. And in any event, because the findings could be issued after the fact in a written order, it's unclear when probation would have expected the appellant to object. And so the lower court's failure to specify why it found the hearsay to be reliable is an independent reason why the order should be vacated. The third reason that the order should be vacated is because there was a problem with what I would say causation, that under the statute, the child could only be committed upon a showing of proof of, by clear and convincing evidence, that he was facing an imminent risk of serious physical injury because of the substance use disorder. Now, the lower court identified a number of problems that the youth faced because of the drugs, but these were really societal or went to his well-being, that he had his relationships affected with his relatives, that it changed his personalities. But these are not the sort of considerations that are properly considered in entering an order of commitment. The only thing that would justify a deprivation of liberty in this case is if it was necessary because the child was at risk of physical injury. Now, although probation or the petitioner references the fact that the child had a heart condition, and one might believe then that the marijuana went to an imminent risk related to the heart condition. The clinician, in fact, disproved causation on that. Right after the clinician said that the child had a substance use disorder or cannabis use disorder, the clinician on her own then volunteered, but I couldn't get a handle of how that would have affected imminent risk as the heart condition. Judge, that testimony in and of itself, I think, is dispositive. That the clinician was saying, I can't say that there is imminent risk because of the condition. That alone compels the vacatur of the commitment.
So the evidence that he was found passed out essentially in a stairwell, that in your mind is not a risk of physical injury, considering his age?
That seems to be related to the intoxication, right, that he was drinking, that he was passed out, I think.
It's unclear.
And so that can't be considered, that is a completely separate charge you would see in the statute. Substance use disorder and alcohol use disorder are two separate.
It's not clear whether it was because of the alcohol or something else.
Judge, I don't recall seeing anything in the transcript that led me to believe that it was because of marijuana.
Right. Well, just on the question of risk of physical impairment, would that qualify as a physical impairment, putting aside the causation problem?
I would say no, Judge, because there has to be a nexus, right? Case law.
Putting aside the causation issue,
Okay.
would the fact that someone as young as he is passed out in a stairwell, would that qualify as a risk of physical impairment?
I think, again, if the testimony, I think we would need to know why he was passed out. If he was passed out because he was drinking, I would submit that it would be improper to use that as a basis for a substance.
Passed out because he was using substances, hypothetically.
Yeah, hypothetically.
Would that be enough to prove a risk of physical impairment?
Yes, that could be the case.
Counselor, do we know when the evidence purported him to be passed out? I believe the aunt talked to someone at the school, and they reported that they found him passed out. Do we know when?
All of this, let me just set the stage here, and that this is a very fast-moving proceeding. And so I don't know that the record is developed to say exactly when he was passed out. There's a reference in the affidavit that's attached that said that he was found in stairwells, but it doesn't provide a time. And so it's unclear when that was. I would note, Your Honors, that to the extent, again, it appeared that the petition was focused on the condition with the heart. But I would note that the evidence was that this was a condition that had been known about for years, right? And so that is further evidence that this is not an imminent issue, that if he was using drugs, marijuana, whatever, for a number of years while he had this condition, it can't be said that he was at imminent risk of having an imminent problem because he had been doing it for years. Moving on to yet another problem with the lower court's order is that even if all of the elements were found, that is, that he had a substance use disorder, that he needed to be committed because of imminent physical harm, that even then he could not be correctly committed until and unless the court did an analysis of whether there was a least restrictive alternative. That if he could be treated for drug use in some less restrictive environment, he could not be committed to the drug rehab facility. And the lower court did not consider, didn't raise the issue, didn't look at it, didn't explore it, didn't ask whether there was
What
any.
about the probation officer's affidavit? DCF has made repeated efforts to place the child in a safe place to receive outpatient assessment and treatment. They have been unable to keep him safe.
Certainly, had the court explored that, it would have been a factor that could have considered whether or not there were other suggestions. But the court didn't do it. The court didn't look at it, although it was in the affidavit. Probation makes the argument that, well, there were other avenues that were explored or mentioned in closing argument. But that, doesn't show that the court actually considered it. It doesn't have to be an exhaustive search, I'm not saying that, but there has to be something that the court has to consider as to whether or not the child could have been treated.
Would this issue also be a remand for findings then, and not a reversal?
Again, Judge, I was asking that this order be vacated,
Yeah.
and to be honest with you, it's a little unclear what happened. But again, if the whether it be remand or whether he would be eligible for another petition, it's a little unclear, but I would ask that this order be vacated.
Okay.
Unless the court has any other questions, I would rest on my papers.
All right, thank you.
Thank you.
Good morning.
Morning.
May it please the court? My name is Kelly Amazi, and I'm an administrative attorney on behalf of the Massachusetts Probation Service. I'd like to start with what this case is about. The court should affirm the lower court decision to commit the minor for 90 days for substance use disorder under the General Laws, Chapter 123, Section 35. This was a case about a 13-year-old with a serious heart condition who had received 2 surgeries for this said heart condition and was looking at an upcoming surgery in September of 2023. The child was on the run from DCF placement for 2 months and not attending school and smoking marijuana on a regular basis. Based on these facts, the juvenile court was justified in ordering the Section 35.
What is your evidence that he was smoking marijuana on a regular basis?
Based on the clinician's testimony, Your Honor, there was evidence that not only did the mother confirm that there was regular marijuana smoking, but also so did the aunt, as well as the cardiologist and the nurse, which both the cardiologist and the nurse, which the clinician interviewed, have been treating this minor for the past 3 to 4 years for that serious heart condition.
Can you tell me where in the record any one of those 4 sources say there's regular use of marijuana?
In the record, I can look to, if you give me just a moment. There's reasonable inferences throughout the entire transcript, more specifically when the clinician was giving the testimony. There were instances where the mother did explain to the probation officer that she felt that her child was in danger, and that this child consistently does smoke the marijuana.
I don't. You're saying in the record there's evidence that the mother conveyed that to the probation officer?
Yes, Your Honor.
During the hearing?
From the affidavit that was given by the probation officer.
So the affidavit, it states the minor smokes weed daily, something like that, correct?
Yes, Your Honor.
And you're saying the record supports an inference that the mother provided that to him?
I am saying that it does. Not only did they get that information from the mother, but also from the aunt, in which there were instances given in which the minor had gone and broken into a family member's car based on the fact that there was marijuana in there that the minor wanted, had been...
And when did that occur?
These instances occurred beforehand, but these would be firsthand accounts based on what the knowledge of both the mother and aunt had and had given to...
Well, that's a question, though. We don't know how the aunt knows. So the clinician said, the aunt said that the minor broke into the cousin's car. Did the aunt see that?
That is not made clear to me.
Did somebody tell the aunt?
It would not seem that that was made clear in the transcript. However, there is enough reference from 4 different sources to show that there is a connection that this person has some sort of substance use that involves marijuana.
But that's different. I mean, even if we accept there's enough evidence that he used marijuana habitually and chronically, let's just assume that, that's not enough to establish he has a substance use disorder, right? There has to be a nexus to some substantial injury, where's the evidence of the nexus? I mean, there's no question this minor had a whole host of problems, but there has to be a nexus, right?
Yes, Your Honor.
Okay, so what's the evidence of that nexus?
based on, the court had to find that, yes, that he suffers from a substance use disorder. There was enough substantial reliability based on the information that was received from the clinician. But the court may find that there is a likelihood of serious harm in one of three ways. One of those ways would be the substantial risk of physical harm to the person themselves. The second could be a substantial risk of physical harm to other people. But thirdly, which is what this court particularly relied on, is the very substantial risk of physical impairment or injury to the person himself as manifested by evidence that such person's judgment is so affected that he is unable to protect himself in the community, and that reasonable provision for this protection is not available in the community. I submit that because this minor was on the run from safe protection from DCF, there had been instances of him being found passed out in a stairwell, not in school, passed out to the point that he had urinated on himself. It is likely that this is the connection there in which the court used.
There's scant evidence that that was because of his marijuana use.
I don't disagree with you there, Your Honor. However, the point of the fact that this minor was not in school during this time and had been on the run for the past 2 months, this does go to show that the judgment of this minor and the fact that there had been other instances, accounts that both part of the medical advice that the doctor had given was to stop smoking marijuana in order to help the congenital heart disease that he carries. So because of this particular court relied on that third prong to show that there was a serious harm, and that this also, if I may, was not typical adolescent use or typical adolescent behavior. As my brother brought forward, there were some instances in which there were some traumatic things that this minor had experienced, but nothing to the fact that it, it's been made clear through the individualized findings that it is determined that the likelihood of serious harm to be because of the minor's substance use disorder and not just developmentally typical misbehavior. And that was found in the
There's a lot of trauma in his life. He'd had a friend murdered, was that correct, or a friend shot?
Yes, Your Honor, there was a friend that was shot.
So there are other factors in his life that may have explained some of these behaviors that manifested?
It could be argued that, but based on the running away, the criminal activity, the aggression that he had towards his mother and his aunt, in which it had affected their relationships, and some evidence of drinking, they were not just due to behavior problems. In fact, the juvenile court found that the minor's use of the marijuana affected his judgment so bad that he does run away from safe placements. He wasn't following the medical advice given to him by taking the aspirin that he needs to take and stopping the smoking of the marijuana.
The statute requires that there be a very substantial risk of physical impairment or injury. So what is the physical impairment here? Is it the heart condition?
It is the heart, and
So
it's congenital heart
How do you
condition.
get past the clinician's testimony that she wasn't able to get a solid answer on imminent risk? And GP says that imminence under the third prong is even more important because the statute frames it as very substantial risk. So how do you establish imminence?
In this particular case, Your Honor, the juvenile court properly concluded that the seriousness of the anticipated harm to this minor was so severe that it countered any perceived uncertainty or imminence. Again, if I may redirect it back, this minor was 13 and not 16 like the minor that the SJC considered in the matter of a minor. This minor has not only just a serious but also a complex congenital heart disease with with the specific treatment plan that he's continuously ignored, unlike the respondent that was in AM. And this
He's
minor...
had the condition for at least 4 years, is that fair to say?
Yes.
At least
He
4
was
years he's had it.
diagnosed at 9 with this condition. And this same cardiologist and nurse have been the same treatment team that's been with this minor since that time.
I have a question for you. In a footnote in his reply brief, the juvenile argues that the juvenile court did not have jurisdiction over this Section 35 petition because it was filed by a probation officer, and he argues that a probation officer is not a court official within the meaning of Chapter 123, Section 35. Do you have any response to that?
I would respectfully disagree. A probation officer does report things to the court, is also in the duty and within the scope of bringing information and also monitoring probationers as they are on probation. So I would say that a probation officer is a court official, and I would respectfully disagree with my brother's statement there.
Do you agree it would be a question of subject matter jurisdiction?
No, Your Honor. This was brought forth in the proper court with the proper tools. The probation officer is a court official, and it was brought forth correctly. And I would stand firm on that.
Okay.
If I may go back to the standard of review here, that it's within the purview of the judge to weigh the evidence, assess the credibility of the witnesses, and make findings of fact, which this court must accept unless it's clearly erroneous. And in this case, it has not been clearly erroneous. And so, Your Honor, with this, I'd say that the court should affirm the lower court's decision, that this was the proper decision made for this particular case, and I would rest on my brief if there are no further questions.
I have a further question.
Yes, Your Honor.
Your brief, you rely on evidence, again, from the affidavit, this affidavit from probation, that the juvenile smokes weed daily, correct? In your brief, you argue that it was a significant factor or a factor that goes towards a substance use disorder, that the affidavit, the sworn affidavit, stated the juvenile smokes weed daily, correct?
Yes, Your Honor.
In the judge's findings, when he concluded, he stated, and I quote, it's on page 40 of the revised appendix, after consideration of the admissible testimonial evidence that was provided during the hearing and all the inferences that could reasonably be drawn from the evidence. So you don't consider that affidavit testimonial evidence, do you?
I would not say that it was testimonial, Your Honor.
So for some reason, the judge seemed to go out of his way to not consider that. It's unusual, well, it's not unusual, but he framed his finding as testimonial evidence. And we don't know whether he implicitly found it wasn't reliable. We don't know why he did that, but you agree that he confined his decision to what was testified to.
Yes, and I know that there were concerns regarding the upcoming surgery that the minor had. I know that the lower court did make necessary statements placed on the order so that all parties involved would know and be on the same page about this upcoming surgery. And so I do think that there was thought that was put into making sure that this particular minor would not be held for the considerable 90 days. In fact, he wasn't. It was less than 2 weeks. So.
Okay, thank you, counsel. Thank you
Thank
both.
you,
The
Justice.
case is submitted. All right, our final case is Department of Children and Families versus Father 2023 P 1012. And I would remind council that this case is also impounded, so please refrain from using the parties' names. You can refer to them as mother, father, and child.
Thank you, Your Honor, and thank you, Justices. May it please the Court. My name is Andrew Lavender. I represent the father in this case who is requesting that this court vacate the order of the juvenile court terminating his parental rights. Your Honors, this case is about whether the Commonwealth owes the bare minimum of legal protections to its incarcerated parents or not. In this case, DCF largely ignored an incarcerated father, denying him visitation or information about his child, and apparently making contact with him only once over the course of 3 years, solely to give him an action plan that was full of tasks DCF knew were inaccessible or impossible for him to achieve. The only activity that DCF took on with any enthusiasm was moving to terminate father's parental rights, which the lower court did, blaming father for all of DCF's failures. It is inconsistent with everything we know about due process to allow courts to terminate parents' rights based on facts that are the creation of the state. This court should not let this stand. It's essential to due process. It's a fundamental aspect of due process that every party should have the right to a meaningful opportunity to be heard and a meaningful opportunity to rebut the facts against them and to present positive evidence in their own defense.
I was with you on the first part. He's entitled to a meaningful opportunity to be heard, which he received because he had a trial and he participated. I'm not seeing how there's a due process right to develop favorable evidence.
I think the argument here is that state action denied this father of the opportunity to have a relationship with his child and to engage in services, and then his lack of a relationship with his child and his lack of participation in services, his lack of follow-through in his action plan was used as a basis for the termination of his parental rights. And
maybe that's a statutory argument that DCF didn't comply with its obligation to make reasonable efforts, but due process is, that's a hard argument. So let's say that maybe what the father should have done, let's say he files a motion for a continuance of the trial, saying, because my paternity hasn't been established, they're not letting me have visits with my child, please continue the trial. And the judge says, no, this child's waited long enough, denied. That would be a due process violation, and if so, how long would the court have to wait? How long would the court have to postpone the trial in order to satisfy due process?
Those are all good questions, and I agree that it is a hard due process argument. I think there is a strong reasonable efforts argument that I was also going to make about the statutory obligation. I would suggest that, generally the process is that after a care and protection adjudication, if the parents' rights are not determined, that there's, an opportunity for review and redetermination every 6 months. So that would be what I would suggest as the period that could have been allowed here for the father to have an opportunity to engage in this case the way a parent generally would with DCF, and he just had no opportunity to do that here. I think the due process argument isn't to a degree, it's a substantive due process argument, that the state has obligations that it's meant to fulfill before it moves to terminate a parent's rights. And here there's no dispute that this father was not receiving visitation, he was not getting services based on the fact that his paternity was not adjudicated. And at the same time, he sought to have his paternity established, but there were delays that were also the result of state action. And so wherever he turns, he's got a barrier to seeking to establish paternity, and then he's denied visits, he's denied services based off of his lack of established paternity. And then at the end they say, oh, you didn't do any of these things that we asked you to do, so we're terminating your parental rights. A couple things I was going to respond to in the appellee's briefs with respect to due process. So first, they both argue that they distinguish the case of Arlene, pointing out that in that case the father had filed his paternity prior to the adoption proceeding, so therefore had attempted to establish paternity before the case was filed. Here, father didn't do that before the care and protection. But I think what's different here is the complaint action. The complaint action is not that he didn't receive notice as it was in Arlene, but that it wasn't right to terminate his parental rights at that time. And he absolutely had filed his paternity 9 months before the complaint of action. So I think that the chronology here, where he unequivocally took a step to establish paternity well before the trial and was not able to do that, that's where the principles that are laid out in Arlene and also the Supreme Court's decision in Lair applied to this case slightly differently.
Neither Arlene or Lair established some sort of constitutional right to have paternity adjudicated before the trial, right? I mean, so as you said, the due process violation in Arlene was lack of notice.
Yes, that's right.
So then the statements that your brief, I don't think it's your brief, whoever wrote this brief relies on, that goes to the disposition, right? So there was lack of notice, there was an adoption decree entered, and the putative father said vacate the adoption decree, and this court said, no, we're not going to do that because it might not be necessary if, in fact, you are not the biological father. So first you do paternity, and then we'll decide what to do with the decree. So it was just the remedy, right? It's not a right.
I agree that Arlene does not specifically create a right to have paternity determined before a termination trial. I think, though, in that case, it says that the court on remand should start with paternity because that was the most efficient way to go about it in that situation where the case was already here at the appeals court. The decree had been entered. If the father in that case was not, if the paternity came out that he was not the father, no further action would be needed. So that's the first step. Here, the first step, when my client's trial attorney objected, the first step should have been establish paternity and then go from there. So in either situation, you're starting with the paternity before you take other action. It's just in that situation, the decree had already entered. So that was more, I think, a procedural situation than it's conclusively saying it's okay in future cases to go ahead and terminate a parent's rights or enter an adoption when you know a paternity is pending. I don't think that that's at all what we take away from Arlene. I do think that this is sort of an extension of Arlene and Lair that we're arguing for. It's not definitive, but it does say very clearly that before, when the paternity is pending, before anything else happens, that should be resolved. And I think here it really was material because there's undisputed evidence that father was not getting the visitation and services he would normally get because of the fact that he was putative. One specific thing that I think is really telling is in the action plan that he was given, he's required to participate in biweekly in-person or virtual contact with the child to allow the department to assess his parental capacities. And yet the social worker specifically testifies, I told him that we would only set up visits once he'd established his paternity.
What if there were 3 putative fathers, and DCF didn't know which one was the father, and for some reason the testing hadn't been done earlier on? Should DCF offer them all visitation? Let's say they're all in prison. Bring the kid to prison for visitation with all the putative fathers before their paternity has been established?
I don't think so, and I think that's one way in which this case is different, is that I don't think there was not a significant question as to whether this was the child's father. I think there's some evidence in the record that the child at one point believed that his younger sibling's father was also his father, but I don't think that was ever something that the mother actually believed. I think that the child that was who he was living with, a male figure in his life. So I don't think there was a significant doubt, although the paternity had not been resolved. And I think the other difference is that DCF gave him an action plan saying participate in visits, but then doesn't allow him to visit because his paternity hasn't been established. So I don't think you can have it both ways. I think in that example, if you had 3 putative fathers, and it could be any of them, and none of them have taken definitive steps, I don't think the department is necessarily required to have the child visiting with all of them. Ideally, we would resolve the issue of who was the father, and then offer visits to that father, which is what father, in this case, is suggesting should have happened, and unfortunately didn't.
So he waited 2 years before filing the complaint to establish paternity, right?
Yes, Your Honor. So it's a question, and I think in the record, there's exhibits from DCF that state, and it's argued in the brief that prior counsel filed, there's multiple places where DCF states that DOR was not doing testing in prisons during that time because of the pandemic. They were not entering prisons to do that. And so father didn't, he filed his petition when DOR began to. Now, maybe he could have filed it and then it would have just waited, but he did file it once DOR began to do testing again. That's what the record shows about that issue.
The record shows that it wasn't until April 2022 that DOR was beginning to do testing again?
I don't know that the record is that specific, but there are multiple 21A, Section 21A reports that the department filed throughout, that are dated throughout the case. I don't have the exact dates right in front of me. And permanency reports under Section 29B that both, in those, they say, you know, the DOR is not doing paternity testing in prisons at this time. So I don't have the exact dates, but Your Honors have the record in front of you also. You can double check me on that. But even if we say that he could have filed it sooner, he still did file it 9 months before the complaint of action here. So he unequivocally did take steps to try to establish his paternity and to try to be engaged, and he just ran up into a brick wall everywhere he turned. And I don't think it's consistent with fundamental notions of fairness to say to a parent, here's a list of tasks that we want you to do. Also, you can't actually do any of them because of state policies, and then terminate your rights and say, well, you didn't do all these tasks that were given you. I think this, and it was a material error because incarceration alone, we know, incarceration alone cannot be the sole basis for termination. And here, if you take away the fact of his incarceration, there's, you know, very short findings, but they several times, refer to his lack of visitation, his lack of knowing about the child when he wasn't being given information, and the fact that he didn't engage in these services that he was assigned. Coming to reasonable efforts, which Your Honor raised at the beginning, I think there's no question that the department did not engage in reasonable efforts here. The judge actually only said DCF made reasonable efforts to engage with father, but we know the statute doesn't say make reasonable efforts to engage. It's reasonable efforts to prevent the need for removal or to reunify as quickly as possible if the child is removed. And that's not
what about the waiver?
I'm sorry?
What about the waiver?
Yes.
He didn't raise it below, right?
Not explicitly, Your Honor. And I would note with that regard that, father, I think, was acting in reliance on statements that had been made to him by DCF that they would offer him visits and that they would do these things if he established his paternity, and he did file to establish his paternity, which the lower court was aware of. I believe the paternity action was in the same court. The lower court also knew that these issues were going on because it had notice from DCF's filings of those 21A reports that I had noted that stated that this was going on. The trial attorney also, cross-examined on these issues of reasonable efforts, and the judge recognized that it was at issue, made findings, and I think the findings can't be sustained. I mean, one finding says, that the social worker did not have to make referrals to the father for programs in this circumstances. And I think that's belied by the fact if you look at the action plan that was given to father, it has a few tasks for the social worker as well. And one of the 3 tasks for the social worker was to make referrals for the father. So to say that he didn't have to do that, that was one of the tasks that the state gave itself, and he still didn't do it. Another task was to make monthly visits. We know he only visited my client once in 3 years, not monthly. I think the other task was to stay in touch with collaterals to find out whether father was participating in services. I don't think it's clear whether the social worker did that or not. However, he did admit that he didn't actually know if there were any programs that father could participate in prison. So I think it's unlikely that the social worker was reaching out to programs that he didn't even know whether they existed or not. And I think it's very harsh to criticize the father for not participating in programs when the social worker himself could not attest to whether such programs even existed. I've made all the points that I came here to make, so unless your honors have any other questions.
Okay. Thank you.
Thank you all very much.
We'll now hear from counsel for DCF. Splitting your time evenly?
Yes, Your Honor, approximately 8 minutes for the department and 7 minutes for
Okay.
counsel for the child. May it please the court, Richard Salcedo for the Department of Children and Families. The department is asking this court to affirm the trial court's decision finding father unfit and terminating his parental rights, and also approving the department's plan of adoption by the child's maternal relative, where he's been placed since 2022. He is currently 12 years old, the child. Father argues that he was ignored by the department. However, the record shows that this case began in May of 2020. Father at that time was whereabouts unknown, and the department located him within 5 months and filed a motion to amend the petition to add him as putative father, and soon after he was served and was appointed counsel. The following year, in August of 2021, the department filed its notice of intent, and it wasn't until 8 months later that father filed his complaint to establish paternity. So I'd argue that any delays in establishing paternity was largely on father's part.
But is he right that DOR wasn't doing the testing during that time because of the pandemic?
There was some delay in conducting the testing. The agency that DOR was working with was having some issues, but I don't recall that that's the reason why father delayed in filing his complaint. There was also in the record some mention of father not being available on one of the occasions when testing was attempted. With regard to, as your honors mentioned, with regard to the due process argument, father did have a meaningful opportunity to be heard in this case. Appointed counsel, as I had mentioned, he testified at trial. His appointed counsel, who was appointed in August of 2020, remained his attorney throughout until the termination trial in January of 2023. With regard to visits, the department was not denying father's visits, would have facilitated them, but at time when he was incarcerated, the policy at Bridgewater State, where he was initially incarcerated, was that they would not provide visits to putative fathers until they had established their paternity. The other issue is that visits were impacted also by some COVID restrictions, and also father had been transferred at one point from Bridgewater State to another facility and placed on psychiatric hold. There was also evidence from his own testimony that within 4 months of the trial, he'd been placed in solitary confinement. So visits were also impacted in that way. Also, the child himself does not know this father, never had a relationship with him, does not know who he is, and has no interest in visiting with him. So that's another issue, even if the other matters could have been addressed. With regard to services, the department had, just by virtue of father's incarceration, the normal referrals that the department would normally make or be able to make were limited due to the incarceration, but the department did develop the action plans and met with father. There were some services that he could have engaged in, including parenting classes, and he could have engaged in fathers groups, but Father indicated that he had not engaged in anything, not even the bare minimum, to indicate that he was engaged in some services that he could have presented some evidence on at trial, but he failed to do so. Yeah. So, unless the court has any further questions, I would urge the court to affirm the trial court's decision.
Is there anything in the record to show that maybe part of the reason why the father delayed in filing the petition for paternity was this risk of sounding callous, because that didn't become front of mind until after the mother died?
Mother died in
May of 21.
May of 21, and he filed his motion for paternity in August. I'm sorry, in April. I didn't see anything in the record to that effect, Your Honor, so thank you.
Good morning, Your Honors. May it please the court, Jeremy Thierman, and I'm proud to represent the child in this case. It is just one child. One of the themes that I think should be recognized in this case
Would you just lift the microphone a little bit? Thank you.
I'm sorry. I'm a little too tall. One of the issues in this case, and it was language from the Arlene case that my brother had cited, and it talks about grasping the opportunity. And I think, specifically with the due process issue, the father in Arlene had grasped the opportunity to play a role in that child's life by taking action immediately. In this case, the child is currently, he's 12 years old now. He was 2.5 years old when his father was sentenced to the prison term he's serving right now. And he was 8 years old when the care and protection case was filed. I know that there's been a lot of reference to the opportunity that father had during the course of the CMP to do different things, to have visits, to pursue his paternity rights. But I would ask that this panel really look at the opportunity that the father had had since the child was born, since 2012. The evidence was very clear in the record that father had never paid child support. The father had never petitioned the court to establish his own paternity, had never sought visitation with this child. And although he did testify that he played some role in the child's life, the trial court specifically did not credit that testimony. So we're not just talking about this 2.5 years or so in terms of the care and protection. We're talking about somebody who did not grasp the opportunity to be a father for a very long time. I won't say any more about the due process issue because I think it's been covered. But with respect to father's unfitness, the evidence is overwhelming that father was unfit in this case. Father, in addition to the things I've already mentioned, father has a significant criminal history. He had participated in the distribution of heroin, and he conducted that business with a sawed-off shotgun, and that's what ultimately landed him in jail. That was a very poor choice on his part, and with respect to my brother's argument regarding incarceration, this isn't simply about incarceration. This is about the facts that led to that incarceration that speak to his ability to safely parent this child. And I think that that played a large role in the underlying case. More importantly, although my brother may have some point with respect to DCF and what they did or didn't do, number one, I would suggest that that argument wasn't preserved. But even if it was, there was no steps taken by father to improve his own case. He didn't seek out any classes on his own that may have been available to him. In fact, he said he hadn't even looked into it. In addition to that, he petitioned the court to get video visits or do anything of that nature. He never raised these issues at a 29B permanency hearing, never brought a motion with respect to Rashida, best interest motion, or anything of that nature.
He wouldn't be entitled to virtual visits, right?
I'm sorry, Your Honor?
He wouldn't have been entitled to virtual visits either, right, until his paternity was established?
I don't believe he would have been entitled to them.
Well, the policy would prohibit it, right? The DCF policy?
No, I don't believe that's the case, Your Honor.
Okay, so someone who hasn't been adjudicated to be the father can have virtual visits with the child?
I think in a case like this, so generally speaking, yes. And a putative father will have visitation in person or by video. I just say video because that would be the only practical means in this particular case, but they absolutely have a right to
it was the prison
visitation.
policy that prohibited the in-person, right?
Correct.
But prison policy wouldn't have prohibited the video?
That I'm not aware of, but the point that I was trying to make was that the father didn't make an effort to even see if that was an option. And this is more than just the father not doing some of these things. I mean, there's obvious special needs that this child has that the father did not avail himself of any services to try and educate him with respect to those needs. The child has ADHD for which he's medicated. He also has difficulty sleeping. He has anxiety, and he suffers from migraine headaches from time to time. And also during the course of this case, he lost his mother, which is a significant blow to a young man. And I think that it would be commitment upon the father to understand what the needs of his child were to be and how he planned to address those. None of these things, father just didn't make an effort to do any of these things. He's not in a position as a practical matter to care for his child. He hasn't proposed an alternate plan of care that would allow the court to consider not terminating his parental rights. And the young man is in a pre-adoptive home with a paternal relative that he's well adjusted to and is doing quite well. So we'd ask that you uphold the trial court's decree.
Okay, thank you. Thank you to all counsel. The case is submitted. That concludes our session. Thank you to our court officer, our timekeeper, our clerk's office. I know we have a group of interns here. We'll take a very short break, 5 minutes, and we'll come back out and be happy to speak with you.